Welcome back to In the Know. For the last hour, we've been talking about separation and divorce. Now, Andrew, before the break, we were talking about children, and when children are involved in divorces and the divorce proceedings. Can we just wrap up the points about child support? Because that is always a big issue when it comes to custody of children. Am I correct?
Well, some people will look at the children and say, I want the child to live with me so I get the child support, or I don't have to pay child support. One of the problems with that is people will start influencing the children to get them to come and live with them, and in essence go on a campaign of saying why they're wonderful and the other parent is not. It's a horrible thing to do to your kids because it will mess them up. One of the things I always say to my clients is love your children more than you hate your former spouse. And remember that, because if you're trying to go on this campaign, like I said before the break, giving your child a car to get them to come and live with you is not teaching them a good life lesson. Or another tactic people do is no curfews for teenagers. You can stay out as late as you want. You don't even have to come home if you don't want to. And then a 17-year-old will move over to the parent that suggests that. But the problem is long term, what are you teaching your child? And how is your child going to turn out? Put that ahead of the child support you're paying.
And are child custody cases always taken to court? Is that always decided in court by the judge in the end?
No, frequently they're resolved. The older the children are, they're going to decide with their feet, meaning they're just going to go live where they live.
Right.
That 17-year-old, it's not going to be in front of a judge. It's going to be the child who decides it. And younger kids, sometimes you know the lay of the land. I said earlier on in the show, the Office of the Children's Lawyer can get appointed, and frequently they'll set out a position, and after you read their report, you realize you don't have a case or you have a great case. And that means somebody decides, I don't want to go to trial, because if I go to trial, I'm going to spend a ton of money on my lawyer. And when I say a ton of money, it could be 50, 60, 70, 100,000 plus. And if I lose, I got to pay the other lawyer's fees too.
Right.
That's expensive. For most people, that's financial Armageddon.
So that's a great segue to our last topic of the night, alternatives to going to court. If you can explain, Andrew, what are the alternatives, and I guess what is mediation? Okay,
well, there are various alternatives. One of them is direct negotiations with lawyers where you try and resolve the case on your own. Another one is mediation. Mediation can be done where the parties go on their own without lawyers present and try and resolve a dispute with a mediator. The challenge you have there is that if there are issues of domestic violence or power imbalance, you may not want to have your client going to mediation on their own, because they may not be able to properly advance their position because they're intimidated by their spouse. So that's always a concern, and there's a decision, I think it was last year, by one of the courts that says you have to be very careful about what case is appropriate for mediation and take that into account. Mediation can also be attended with lawyers present, where your lawyers will draft lengthy briefs in advance, and another lawyer who's a mediator will read their briefs and try and work out a resolution from hearing every side's position.
Right.
Another form is a hybrid of mediation and arbitration. What that means is, if the mediation doesn't resolve the case, you then say the mediation is at an end. If the mediator is the same person as the arbitrator, they say they wipe their minds clean of everything they heard at the mediation, and you'll go into an arbitration stage. And an arbitration, and an arbitration is typically like a trial, but instead you've paid for your judge. But the advantage is that your judge is an experienced family law lawyer.
But it's not a full-out trial, because like we said before, those can take a while. Oh, it is. Okay.
It basically is a full-out trial. It's not in front of a judge. It's in front of a lawyer. But the same rules of evidence will apply, or I shouldn't say the same, similar rules of evidence will apply, similar rules in terms of examinations and cross-examinations, and it's horrendously expensive. So people do mediation arbitration because, in my experience, I've only had one of my mediation arbitrations ever get to arbitration. We've been able to settle them at that earlier stage because people don't want to go to the arbitration stage. The other type of alternative dispute resolution is collaborative family law. That's a newer type of form. It's supposed to be a holistic approach to resolving cases. Some family law lawyers absolutely love it. Some of the lawyers in my office absolutely love it. I'm not as keen as some of the others on it. I'm a little bit more reserved in that I think you have to pick the appropriate case, because there are cases where there can be a power imbalance between the parties, and they can use the collaborative process to their advantage. The collaborative process, one of the cornerstones of it, is that your lawyers who are representing you in the negotiation, which is supposed to be an interest-based negotiation, have to withdraw if the case goes to court. And you, in essence, have to start all over again. So there's a very expensive impediment to doing that. And what I've seen in some cases when people come to me is they've spent 20, 30,000 on this process, and they haven't been able to get to resolution. One side pulls the plug, who has more money, and uses that advantage to the other side of saying, here's the deal, take it or leave it, and they feel very weak.
So through your years of experience in this field, what alternative do you see most couples are drawn to?
It varies from case to case. My personal preference is usually the mediation arbitration, because I've had tremendous success at seeing my cases resolved at an early stage and a lot more cost effective than going to court. The court, that's the local court for York Region and Newmarket, is overwhelmed. The judges there, for me to get court dates, sometimes can take 4 to 6 months. There's, as a ratio, the York region, or I should call it Central East, which is the whole region around here, which includes Simcoe and Durham, has about 1/3 of the judges of the city of Toronto, and the combined population is about the same.
And if the divorce cases are up here, then it could take forever for your case to be seen.
I could spend 4, 5, 6 months to get a date sometimes. In Toronto, I can get a date in 6 weeks to 2 months usually. When I go to court in Toronto, there's 5 items on a judge's docket normally. In Newmarket, could be 10 or 12 items. You can think about how much time you're going to get in front of a judge if you're one of 10 or 12.
We have just a few minutes left in this segment. I wanted to highlight the magazine here, the Top Choice. Again, you and your family law group named top choices on the front cover here for family law.
Yes, we won the award. I believe it's 6 years running now for the top family law firm in the Greater Toronto Area. We're proud of our team, that we've worked hard to win the award and be elected to that, or to win that award through an online election through the Top Choice people.
Great. And a headline here is separation and divorce are difficult. I mean, you've been in this industry for a while. How has the landscape changed over the 20 years when it comes to separation and divorce? Is it still really difficult for families?
It is really difficult. They're constantly trying to make it easier, trying to create new rules that are meant to make things simpler. In my experience, usually when something is made to make it simpler, it doesn't work out that way. When they brought in the child support guidelines in the late 1990s, it was supposed to make things simpler. Now there's cases and cases of interpretation about what is somebody's income, how do we get there, different things, and it's become very complex in its own right. They brought in a unified family court here to try and make things simpler and easier and more efficient. It doesn't seem to work out that way. Usually you plan something and there's unexpected consequences that don't necessarily make it easier and frequently make it more complicated.
So Andrew, what's your takeaway message for viewers who are at home listening, to the whole show if they're contemplating separation and divorce?
Understand that you need to treat your spouse reasonably, because what your objective is to avoid being one of those people that has a high conflict case. You don't ever want to be one of those people. And if you can resolve things amicably, it's best for you, it's best for your spouse, and most importantly, it's best for your children.
And it's a reality now to put everything out on the table like we were discussing during the show, and just full disclosure, because it is emotional.
The courts are very clear that you must provide full and frank disclosure. In fact, if you don't do it, the courts have the power to dismiss your case and allow your spouse to proceed without you. And that's an horrendous penalty.
Andrew, I want to thank you so much for joining us on In the Know, sharing all your tips and expertise on this topic. Thank you so much. For you watching at home, thanks for tuning in, and I'll see you next week on In the Know.